Good morning, guys. My name is Shiven Asthana. I am a second year law student from WIPS IP Delhi and an intern at LEXIS and Company. So, today I'll be talking about a topic which is quite prevalent though illegal in India. Like, you might have heard about this, not like personally experienced, but you might have heard some cases about them. So, the topic is ragging. So, what is ragging? Ragging is the term used for so-called initiation ritual practiced in higher education institutions in basically South Asian countries. Ragging involves abuse, humiliation, or harassment of new entrants or junior students by the senior students, often called as freshies. It often takes a malignant form wherein the newcomers may be subjected to psychological or physical torture. In 2009, the University Grants Commission, that is the UGC of India, imposed regulations upon Indian universities to help curb ragging and launched a toll-free anti-ragging helpline. Ragging is a subset of bullying. Unlike various complex forms of bullying, ragging is easily recognizable. In India, ragging is banned in all campuses. Such acts are punishable by fines of up to Rs 550,000, jail terms ranging from 6 months to 10 years depending upon the crime committed, and awarding of certificates that a student had indulged in ragging, which can adversely affect career prospect. Under laws in India, ragging is defined as firstly any disorderly conduct by acts or words spoken, the effect of which is teasing, treating, or handling with rudeness any other student. Any rowdy or undisciplined activity which causes annoyance, hardship, or psychological harm. Thirdly, raise fear or apprehension thereof in the minds of junior. Fourthly, asking students to do an act or perform something which students will not do in any ordinary course, which has the effect of causing shame or embarrassment so as to adversely affect the physique or psyche of a junior student. Some states in India have their own legislations on ragging. Some states which do not have their own legislation on ragging, and therefore the ragging laws in these states in accordance with the central legislations on ragging. The central legislations which keep check on the practice of ragging in India are: firstly, you all know it, Indian Penal Code, that is the IPC. Second, UGC regulations on curbing the menace of ragging in higher education institution 2009. Third, other institute specific regulations. Fourth, every single incident of ragging or abetting in ragging puts an obligation on the institution to get the FIR registered. There are provisions in the IPC which can be used by a student to register an FIR in the nearest police station. These provisions are Section 294, which says that obscene acts and songs; 323, punishment for voluntarily causing hurt; 324, voluntarily causing hurt by dangerous weapon or means; 325, punishment for voluntarily causing grieving hurt; 326, voluntarily causing grievous hurt by dangerous weapon; 339, wrongful restraint; 340, wrongful confinement; 341, punishment for wrongful restraint; 342, punishment for wrongful confinement; 506, punishment for culpable homicide not amounting to murder. So I'd like to conclude by saying this: the primary responsibility to curb ragging would vest with the education institutions. There is a requirement to active participation of media and civil society as well in controlling them. As rightly observed by the Honorable Supreme Court, declaring ragging as a cognizable offence cannot control ragging, as the students going to education institutions should not be subjected to live under fear of police. However, in view of recent impact on the students, these guidelines to curb the menace of ragging were put in place. The court has also have been ensured responsibility to ensure that there is speedy disposal of these matters. The past memory of adverse impact of ragging can only be wiped by strict implementation of these laws. Thank you.